In 2007, there were 6 cases. And if you look at the colors, the purple is a part where the Korean company was a complainant, whereas the others in the gray area, it was a case when the Korean company was respondents, where a foreign other company raised a patent case against the Korean company. So the specifics, the details, I can provide you with more details later on. Always, you can leave your name card with me and I will get you more specific information. And so if you look at this graph, before 2005, there were not many cases, and Korean companies were merely the respondent. Also, after 2005, except for one case, Korean companies were also respondents. But since then, there has been a change. What this means is that now Korean companies are becoming more aware about IP, and their patents has been registered in the U.S. more and more. For instance, in 2009, in the U.S., looking at the patents, number of patents registered in the U.S., Samsung, I believe, ranks 3rd globally, and also LG also ranks within 10 to 20 in terms of the number of patents registered in the U.S. Therefore, we can see that IP is also being recognized as being very important amongst the Korean companies now. So that means that also in ITC as well, the percentage of Korean companies as complainant is gradually rising. In 2009, I think that trend has been started. And to be more specific, this is only in terms of ITC, Section 337 patent cases. Samsung Electronics and LG Electronics, they are the majority. And in the case of Samsung Electronics, in 2008, they were involved in 7 cases. And if we count from 2006, it's 16 cases. And in the case of LG Electronics, from 2007, about 6 cases. Also, Hynix Semiconductor, in 2000, there was a case. It was Hyundai Electronics at that time. And we can see several instances. Also, Kumho, in the petrochemical area, it was settled quite early, but in the case of Samsung Electronics, Hynix, and LG E, they went till the end, and the LG Electronics also in 2009, one case, LG Electronics won 100%. In the case of Seoul Semiconductor, they had a very big litigation case, and they went till the end and saw favorable results. And the trial, several weeks before the trial, I believe they had a good settlement later on. And the Seoul Semiconductor is a very small company, but they raised a very big case at the ITC. It incurred a lot of costs at that time. And the Samsung Electromechanics also is here. And Ficom that you can see here. I believe that they've changed their name to TS System. It's a very small company. And they also was claimed as respondent in the ITC, and they went till the end and they won that case. And the patent holder in the U.S., the U.S. firm, they raised this case. And I don't have numbers about the results of the cases, and in the majority of cases there were early settlements. But recently, in the Korean companies going to the ITC, if we look at the records, the Korean companies are quite ambitious and they're quite aggressive. And in some instances, when the company is very small, they tend to have early settlements without going to the end because of the cost issue. And so now the Korean companies are no longer very submissive, or are they very aggressive. But if you look here, when it says as complainant, it seems Samsung Electronics has in the 6 cases they have raised their complaints, and LG Electronics in 2 cases have raised complaints. In the case of Seoul Semiconductor, the Nichiya in Japan in the elevator industry is the biggest company, about 70% market share. The Nichiya company, Seoul Semiconductor was complainant to Nichiya, and they did get good results. Although it did not go toward the end, about several weeks prior to the settlement, they made a settlement, and I believe Seoul Semiconductor stocks at that time went up by 20%. Stock prices for Seoul Semiconductor at that time. So it was a very good result that they obtained from these patent cases. In terms of technology area, if we look at the future trend, I don't think this shows us the trend for the future, because this is an analysis based on the past number of cases. And the products of the companies tend to change as well, so it's not going to be indicative of the future trend. In the past, there was a lot of ITC suits concerning semiconductor. Samsung, Hynix, the semiconductor-related technology was the main area in which the suits were raised. But now, cell phones, this is the more predominant area, and now we have the smartphones. So those areas, I believe, will have more suits being filed. Also, the LCD display is somewhat limited. Samsung or LG Display or the Sharp of Japan. Several of these LCD manufacturers, because we have a limited number, there will be these kind of suits filed at the ITC. Whether this is going to continue into the future, and also as to who is going to file these suits. There are a lot of Taiwanese companies in this display area, so the Korean companies might file complaints toward these Taiwanese companies. Who knows? In the U.S., to raise ITC suits, to file ITC suits, in the U.S., the complainant has to be it has to have a U.S. presence. And that is limited to the product which is infringing on a patent. In the case of LCDs, a Korean company, in order to it has to satisfy the condition that it has to have a U.S. presence. For instance, if the Samsung Electronics wanted to file a complaint against Sharp, they have to satisfy the condition to have a U.S. presence. So that's something to consider. And some of them have been very speedily resolved. In the case of chemicals, there were several in terms of cameras. And in terms of home appliance, there was one case. And although it was one case, this was a very huge, big case. This was between LG and Whirlpool. and the Whirlpool versus LG Electronics. This year, February, we saw the final judgment, and LG won in this instance. And Judge Essex was the judge at that time. And so the Whirlpool patent is now, almost all of them are invalid, except for one. And the final judgment was that the one valid patent was not violated. So this became a very famous case in the U.S. because the Whirlpool company has a history of over 100 years. And the people in the U.S., this is a very familiar brand for them. But when Whirlpool filed this suit against a Korean company, LG Electronics, they lost. So they did not appeal. So it was a complete victory for LG Electronics. So when we talk about ITC, we cannot say that we cannot say that we're always on the losing side.
그래서 그러면 이제 앞으로 이제 좀더 ITC에 대해서 이제 더 많이 아시게 되고.
Now you will become more and more familiar with ITC itself and the litigations, and we will be presenting these cases to you. But because of the time limit, I'm going to briefly talk about how to deal with the ITC litigations. Now, first of all, looking at the procedures for ITC, it's different from the court trials in the judicial courts. But there is a difference in that it is completed by 18 months and there are almost no schedule changes, although there are some exceptions. So within a very short period of time, all activities have to be conducted within 18 months. Therefore, there is a humongous amount of cost involved. Therefore, during the ITC litigation, even the costs for attorneys, I have heard instances where the cost for attorneys has gone over 10 million US, even for the Korean firms. I have actually heard these kind of instances, and even legal costs climbing up to 6 to 7 million. So the legal costs are very expensive, and also because this is very rapid, when you are claimed as respondent, because you're not prepared for this, it's a very hasty process. You have to go through all of this very fast. And also, once you are you become a respondent in the ITC, there is no counterclaims allowed. So if you want to counterclaim, you have to have a counter case. In ITC, counterclaims are not allowed. And also in some instances, because you have to fulfill several conditions in order to file a case on the ITC, it's not possible in all the cases. And also, there is no jury in the ITC litigation. For instance, for Judge Essex, once he gives out a judgment, the determination is not final. By the determination by the administrative law judge, it's not final. There has to be a final determination also by the commission. And they can overthrow any determination by the judge. And so any kind of, when the patent holder wins through ITC, almost immediately, of course there are procedures such as 30 days allowed, but